In this lesson, we will focus on Article 3 of the Landlord-Tenant Act, also known as Georgia Code Title 44 Property, Chapter 7 Landlord-Tenant. Article 3 is titled Dispossessory Proceedings, and, in other words, this article is focused on the laws regarding the eviction of a tenant. We'll once again be taking a look at each individual section in the article. The article has 11 sections, beginning with GA Code 44-7-49. So let's get started with Section 49. Section 49 is titled Writ of Possession. In general, a writ of possession is the legal document which a court issues to allow one person or group the legal right to take possession of real property by forcing those in possession out. This is most commonly used in eviction proceedings, but this section is clear that in this case, a writ of possession is in reference to any land or other property being recovered. Additionally, it states that a writ of possession cannot place any additional burdens on the landlord in recovering their property. Section 50 has two clauses. The first applies to all landlord-tenant relationships in general and gives the procedure by which the landlord must begin eviction processes. When a tenant keeps possession of a property past the terms of their lease or fails to pay rent, even if it is during the term of their lease, then the landlord can tell them to vacate the premises, either directly or through an agent or attorney. If the tenant does not vacate the premises and deliver possession to the landlord, then the landlord may swear an affidavit before the appropriate judge or notary public of the facts of the case. The second clause applies only to cases where the landlord is a public housing authority. In that instance, the demand for possession can come at the same time as a notice of lease termination that is federally required. Section 51 looks at the procedures that come after the affidavit has been given by the landlord. At this point, a copy of the affidavit and a summons goes to the tenant, who is now the defendant in the dispossessory proceedings. If the sheriff cannot serve the tenant, then they may deliver the affidavit and summons to anyone who is residing on the property. And if that fails, they can leave a copy at the property and also send by first-class mail. From the day the summons is delivered, the tenant then has 7 days, extra if the 7th day falls on a Saturday, Sunday, or legal holiday, to respond to the summons. The tenant can answer in writing or orally and must make any defense or counterclaim here. The landlord isn't required to be present if the tenant responds orally. The last part of Section 51 concerns tenants who have only been served the affidavit and summons through the mail and having it left at the property. In these cases, if no answer to the summons is received, then the court can file a judgment for possession, but not for any money owed while the defendant is absent. Section 52 requires that in instances where the affidavit and summons were filed for non-payment of rent, if the tenant pays all the rent that is allegedly owed along with all the costs associated with the dispossessory warrant within 7 days, the landlord must accept the rent, and payment acts as a full defense for the tenant. However, the tenant may only use this full defense one time in 12 months. If more than one dispossessory proceedings are brought to collect rent against any tenant, then they must pay the full amount within 3 days, or the landlord will be given a writ of possession. Additionally, If the tenant is not under a rental contract, then paying rent that is owed will not stop eviction proceedings, but will only be factored into any financial judgments made. Section 53 takes a look at when the actual writ of possession is filed. If the tenant fails to answer the summons and affidavit, then the court can immediately offer a verdict for all rents due and for a writ of possession. If a tenant does answer, then they are entitled to a trial to determine the outcome. They are also entitled to stay on the property until the outcome is determined. But they must pay rent in the meantime. But it will now be done through the court. Section 54 looks at the court's role in deciding rent and utilities payments, and how the tenant must now pay it through the registry of the court. Any trial that goes on for 2 weeks or longer will require the tenant to pay through the registry of the court. The tenant is responsible for all utility and rent payments that are expected from the lease and have become due since the dispossessory warrant was served. Section 54 takes a look at several instances when the rent might be in dispute. Either the landlord or the tenant is allowed to provide a rental contract. If there is none and the amount remains in dispute, the court may take the last rental payment that the landlord accepted without written objection as the current rent. The tenant must also pay any amount that they owe under the lease that was owed prior to receiving the dispossessory warrant. The tenant may show any type of receipt that payments have been made. If the amount is in dispute, the court will use the same methods as they did to determine current rent. If the tenant fails to make these payments, then the court will issue a writ of possession to the landlord. Section 54 goes on to say that the money that the tenant pays to the court registry that is authorized by a rental contract will be paid to the landlord, so long as the tenant is not making a claim to that money. And disputed funds will remain with the registry until the trial comes to a conclusion regarding those funds. But any amount that is not in dispute will be paid to the landlord immediately. Section 55 looks at the outcome of the trial. If the tenant is found to be in fault, then a writ of possession is issued. It goes into effect in 7 days after it is issued and will both require the tenant to vacate the property as well as to pay any money that the court found owed, either from rent or other claims. If the judgment is in favor of the tenant, then the tenant is allowed to stay on the property, and the landlord is responsible for any costs associated with wrongly having started dispossessory proceedings. Any money that has been paid into the court registry will be distributed to the landlord and tenant based on the judgment of the court. Section 55 concludes with authorizing the landlord who has received a writ of possession to remove the tenant and any personal property. The landlord can remove the personal property to a different property with permission from the court. And after the writ of possession has been given, it is considered abandoned personal property. Section 56 discusses the use of appeal for a judgment in dispossessory proceedings based on various chapters in Title V, such as bankruptcy. Both the landlord or the tenant may use this as an appeal provided that they file it within 7 days of the judgment. If the tenant is using this as an appeal, they must pay all rent owed to the registry of the court and continue to pay future rent in order to remain in possession of the property. Section 57 states that the entire Article 3 applies to croppers and servants who are in possession of property in exchange for goods and services, but remain on the property after employment has ended. Section 58 states that any false statements made in the affidavit by either the landlord or the tenant are considered a misdemeanor. Finally, Section 59 discusses the removal of transportable housing from the land. If a tenant who has been evicted leaves behind a transportable home, such as a mobile home, after 10 days, the landlord is allowed to have the transportable housing removed from the property at the tenant's expense. There are instructions to do this, including placing a lien on the transportable housing.